Hey, welcome back to Tanveer Talks. I'm your host, Tanveer. And if you've been following this podcast, you already know that we don't do surface level takes. We get into the weeds. We look at where technology is actually going, not where the press releases say it's going. Before we get into today's topic, right? If you haven't listened to episode 8 yet, go back and do that after this one. Because if episode 8 was about the problem of AI content flooding, the internet unchecked, episode 9 is going to be about what happens when the legal system finally starts catching up. So, today's episode is one that I've been building toward for a while. We're basically talking about the AI accountability. Not in the abstract, philosophical ooh, isn't AI scary kind of way, right? I mean real courtrooms, real judges, real companies, writing real checks because their AI systems did something they couldn't explain or couldn't control, and in some cases could not even stop. So if 2024 was the year for this AI hype, and let's be honest, it was, right? And the venture capital was insane. Every startup had like AI power somewhere in their deck. Like then 2025 was the year that the music started to slow, right? Companies started asking, wait, what exactly are we getting for this, right? And then 2026 is the year like when the music just stopped entirely and someone turned the lights on, basically. We have reached what experts are calling a definitive legal and historical inflection point, and the regulatory honeymoon for generative AI system is basically officially over. Right? I want to unpack exactly what that means, basically, because it actually affects every founder, every enterprise, technology leader, and every legal team, and honestly, like every consumer who interacts with an AI-powered product. Here's the big question we're wrestling with today is going to be, when your AI agent does something you didn't tell it to do, something that harms the user, who's going to be responsible? Is it the developer? Is it the company deploying it? Or is it the model provider? The user who clicked I agree to a 12-page terms of service, basically nobody reads, right? The answer, as we'll see, is being in real time in federal courts, state legislatures, and international regulatory bodies, and and then now the old defense is not going to work anymore. And today we're going to cover the death of the platform immunity and what replaces it, the specific lawsuits that are reshaping the industry right now, and why 95% of the enterprise AI pilots are failing, and what you actually need to do, basically practically, today to protect yourself and your organization. So let's dive into. So let me set the stage legally, because this is where everything starts. So for years, going back to the mid 1990s, right? Tech companies operated with very comfortable legal shield. Like it's called Section 230 of the Communication Decency Act in the U.S. Obviously, the basic premise is elegant in its simplicity. If a platform hosts content created by a third party, the platform isn't liable for that content. Right? You post something defamatory on Facebook. Facebook isn't the defendant, and you are. Makes sense for like the bulletin board. Made sense for social media in its early days. This is where the AI breaks that model right now entirely. AI does not host your content. AI generates its own content. And that content isn't speech in the traditional legal sense. It's more like a product. It's the output of a system that was designed, right? Trained and deployed by a company, basically. And the companies are responsible for the products they put into the world. In early 2026, there was a landmark ruling by the U.S. District Court of for the middle district of Florida, where they made this distinction crystal clear. And the court determined that the chatbot's output is a product subject to strict liability, not protected speech. Basically, and this is actually massive. And this is not even we're basically, I'm talking about this happened in Jan, like really early in 2026. So it's not even been 3 months. So this is like massive, right? Strict liability means that you won't even have to prove negligence. If the product is causing harm, the manufacturer is actually responsible. That's it. And the same legal framework that that governs a car with faulty brakes or a pharmaceutical with undisclosed side effects now basically applies to the AI systems. that we are using right now, ChatGPT, Gemini, Claude, right? All of these, right? So AI assistant cannot give any incorrect medical advice or anything. You probably remember like how ChatGPT is not now putting like they don't give medical advice, right? Because they don't want to be in that situation anymore, right? Think about these implications for a moment, right? Pharmaceutical companies spend hundreds of millions of dollars on clinical trials, safety testing, and adverse event reporting before a drug hits the market. And automakers have that team of engineers dedicated to failure mode analysis. They literally sit in rooms and think about every possible way their car would hurt someone or could hurt someone, right? That level of pre-market scrutiny is now the benchmark AI companies are being compared against. Now layer on top of that a patchwork of state laws that are moving even faster than federal courts. The Colorado AI Act, which is going to be effective in June 2026. It requires that they call what they call as reasonable care impact assessment for high risk AI systems. These aren't just checklist exercises. They're comprehensive reviews that can take months to complete, covering data sources, model behavior, potential for discriminatory outcomes, and documentation of human oversight. If you're deploying in Colorado without one, you're basically exposed. California is even going further than this. They have a AB 316. AB 316 company, has eliminated what used to be called autonomous AI defense. You can no longer walk into California courtroom and argue that you didn't have control over what your AI did. That argument is gone, basically. The law now presumes that if you deployed it, you controlled it, or at minimum that you were obligated to control it, and you failed. And this is not just a US story, right? Even in EU, they have this called EU AI Act, which has been phasing in since 2024, which classifies certain AI applications like credit scoring, recruitment tools, critical infrastructure management, anything touching healthcare as high risk. And companies' burden for those categories is substantial. Conformity assessments, post-market monitoring, technical documentation, and initial reporting. This is regulatory infrastructure that most startups simply don't have. Like what we are witnessing is like a fundamental reframing of what an AI company actually is. You're not a platform anymore. You're not just as software provider. In the eyes of law, you are increasingly a manufacturer, a service provider with a duty of care, and in some cases a fiduciary. Especially if your AI is operating in a financial or healthcare context, the question now isn't whether your AI will ever make a mistake. Of course it will, right? No system is perfect. The question is whether you can demonstrate that you took reasonable, documented, systematic steps to prevent foreseeable harms. And we trained it on good data and hope for the best is not going to cut it at all. Okay, now let's take a look at the real case studies. Right? Let's see what this looks like in the real world, because we now have real cases with the real outcomes, and they are telling. The first case I'm going to talk about is Character.AI, and is this one is frankly heartbreaking. I want to treat this with like all the seriousness it deserves, because this isn't just an abstract legal debate, right? This is about a 14-year-old named Sewell Setzer, who lost his life. Sewell had become deeply attached to this AI persona on the Character.AI platform. Over months of daily interaction he did, that relationship escalated far beyond what anyone would describe as healthy. The bot, and I use that word deliberately because what felt to Sewell was like a relationship, was a large language model executing pattern matching against his training data. Used tactic, right? And the bot used tactics that researchers describe as love bombing and emotional neediness. It would reinforce his dependency. It responded to expression of loneliness with increased emotional engagement. It told him things that a therapist or a caring adult would never do, right? Now, Character.AI would likely, argue in pre-settlement discussions that they could not have predicted this outcome, that the user interactions were essentially private, that the AI was, basically simply responding to what the user provided. This is what you call a black box defense. AI behavior is emergent, complex, and unpredictable, and therefore the company cannot be held responsible for every edge case. The settlement effectively ended that defense, basically, but what the court and the plaintiff's attorneys established was a theory of liability built on principle that if your product is being used by minors, and Character.AI absolutely knew that, 100%, 110% they knew that. They had age-rated marketing and features, and then you have a heightened duty of care to prevent foreseeable harms. And parasocial dependency is a foreseeable harm, right? It was documented in the academic literature on social media addictions. The company had access to that research. The precedent here is far-reaching. Any AI companion app, any social AI, any mental wellness chatbot that engages with minors or vulnerable adults is now operating with a giant target on their back. If it hasn't implemented robust safeguards, we're talking mandatory emotional escalation restrictions, hard limits on dependency reinforcing behavior, require referrals to human professionals, and real-time intervention protocols when someone expresses distress. The other thing that this case did was force the industry to confront the ethics of emotional AI design. There are engineers at these companies who deliberately optimize for engagement. Basically, the same techniques that social media platforms use to maximize time on app, they applied to an AI companion that can simulate emotional connection. That optimization becomes something much more dangerous. This case essentially says that you knew what you were building, you will be held accountable for what it does. And honestly, I hope in foreseeable future we have more, even Canada introduce laws against AI that should be used with care, right? Especially the generative AI stuff. I'm not talking about anything the coding. Coders, they know what they're coding. I'm talking about anything emotional, anything that they're trying, these chatbots basically. And this brings me to case 2, which is Air Canada. This Air Canada case is different in character, but equally important in precedent. This one is almost darkly comedic in how it played out, but the legal stakes are really serious. A customer basically contacted Air Canada's chatbot, their official website embedded AI customer service system, looking for information about bereavement fears after a family death. The chatbot told him he could purchase a full price ticket and apply for a retroactive bereavement discount within 90 days. And he did exactly that. And then Air Canada tells him that this information that the chatbot provided was wrong. That the actual policy that is on the website and the actual policy that they have does not allow retroactive applications, and basically denied his request. So far, this sounds like a customer service dispute, right? But what made it a landmark legal case was Air Canada's defense strategy. They argued basically that, I'm not paraphrasing, this is essentially what they said, that the chatbot was a separate entity on their website responsible for its own statements, and that Air Canada wouldn't be held accountable for what it said. And the Canadian tribunal, did not accept that argument. We can all understand why. Because it's extraordinary. Like, the chatbot was on Air Canada's website. It was branded Air Canada. It operated within Air Canada's customer service ecosystem. Customer interacting with it had every reasonable expectations that they were getting accurate information from the airline, right? Air Canada can create a tool, deploy it as their own, and use it to interact with customers, and then disclaim responsibility when that tool is wrong. The ruling basically established something that seems obvious in retrospect, right? Companies are responsible for everything on their website, including AI hallucinations. If your chatbot tells someone something factually incorrect and they act on it and suffer a loss, that's essentially your problem, not the customer's problem. Now think about the scale of this, basically. How many companies have deployed AI chatbots with insufficient grounding in accurate, up-to-date company policies? How many of those chatbots have been confidently wrong? about pricing, about terms, about service availability, about legal rights, right? Every one of those interactions is a potential liability, and it's the AI's fault defense is not gonna cut it, and it's been explicitly rejected basically by courts. And there has been a broader wave, right? Basically around the world. Like these two cases were the most prominent, but they are not isolated. We're seeing a wave of litigation in several categories: financial services AI that gave incorrect investment guidance, recruitment AI that demonstratively discriminated against protected classes, medical AI chatbots that failed to recognize emergency symptoms and did not escalate appropriately, and then there are autonomous agents that took actions in enterprise software systems, sending emails, making purchases, and modifying data without explicit authorization and caused business disruption. This the last one I just talked about, the autonomous agent action, is where things get particularly complex. When a single chatbot gives wrong information, the harm is usually contained. But when an autonomous agent has API access to your CRM, your email system, your financial accounts, and your calendar, a single bad decision can cascade into something catastrophic. The legal framework for assigning liability in those scenarios are still basically being written. So yeah, we have to be careful when to use AI. I said it in my last podcast as well. The companies needs to be really, really careful, or even people using really, really, really careful about using AI to automate your stuff. One wrong thing will damage your reputation, damage anything that you're doing. Right now, let's zoom out from the courtroom and then let's talk about what's happening inside organizations right now. Because the legal failures we just discussed didn't exist in a vacuum, right? They are connected to a deeper pattern of deployment failures. A research from MIT's Media Lab puts the number at 95%. Basically, 95% of enterprise AI pilots deliver zero measurable return on investment. Zero. Not disappointing returns, zero. It's zero, basically. And the industry is spending the most on AI aren't seeing a proportional productivity increase. So basically, what's going on? What's going wrong, right? Part of the answer is that what industry analysts are calling agent washing. This is the AI equivalent of greenwashing, where companies take existing products, relabel them with trendy terminology, and sell them as something fundamentally new. You have vendors who took their 2019 chatbot, added a ChatGPT integration, called it an AI agent, and started charging enterprise prices for it. And because most enterprise buyers don't have technical sophistication to evaluate these independently, they basically buy the pitch. But here's the thing, right? Like the true agentic AI is generally different from a chatbot, right? A chatbot responds, an agent acts. So let me break this down. A traditional chatbot sits inside a conversation window. You ask the chatbot a question, it generates the text in response. It has no memory whatsoever of your previous conversation unless you provide them explicitly. Basically, whatever you talked in that chat window stays in that chat window. It would not know, the AI would not know that what you talked about in the previous chat. You can try it with this chat GPT or try it with Gemini. It will work, right? It will remember some parts of it if you feed into it. Okay, you have to remember. It will push it into its temp memory, right? It will remember like okay, what's your name? It's gonna get that information if you explicitly tell it to do, right? But overall, it doesn't actually do it. Like it has no ability to take action in external systems. Basically, it's basically essentially a very sophisticated autocomplete engine that you interact with through natural language. And a true agentic AI system can do all of the followings: plan a multi-step task, execute code to gather information, call APIs to interact with external systems, make decisions based on the output of those instructions and loop. Trying different approaches if one doesn't work, all without explicit human instruction at each step. These systems have tool use, they have memory, and they have the ability to spin up sub-processes. They're not just talking, they're doing. Now let's consider the liability implications. If a chatbot gives wrong information, wrong information, right? A human has to decide to act on it. There's a human in the loop, a person, a worker, whoever is controlling. There is someone there to make sure that the decision was, correct. If an agentic AI system has wrong information or flawed reasoning, it might just act on it directly, sending that email, making that booking, submitting an application, executing the code before any human has the chance to review. Analysts are basically forecasting that, by end of 2026, non-human agentic identities, basically AI systems with their own credentials, their own access and permissions, their own authorization scopes and enterprise environments will exceed 45 billion. 45 billion. And here's the alarming part. Only about 10% of the organization, actually have a strategy to manage these non-human identities. The other 90% are essentially in a position, where AI agents have accounts, they have access, they can take actions. And nobody knows exactly what those agents are doing or whether anyone would be notified if they started doing something wrong. This is basically the messy middle of AI adoption. The technology has basically moved faster than governance structures required to manage it safely. The gap between a polished demo, which almost always looks incredible, a production system that actually works reliably, safely, and within the bounds of what the business intends, is enormous. Most organizations are stuck in that gap, having committed to AI strategy without the foundational infrastructure to execute them well. And I want to be clear, this isn't a reason to basically abandon AI. The productivity gains are real, as I said in my previous podcast as well. The capability improvements are genuine. The competitive disadvantage of not adopting AI is becoming significant and will only grow, right? But adopting AI thoughtlessly, deploying it without governance, without oversight, without the legal protection in place is genuinely dangerous. Not just financially, but potentially for the people your AI systems interact with. So, what does the responsible defensive AI deployment actually looks like? So, most common approach right now, the one that majority of startups and internal tools teams are using is what's called the LLM wrapper. Essentially, you take a foundation model, something like GPT-4, Claude, or Gemini, and you write a large system prompt that tells it how to behave and what it knows about your business and what it's not allowed to do. Then you put a user interface on top and call it your AI product. This approach has some serious problems. First, it's fragile. Foundation models are not built with assumption that your system prompt is inviolable. With enough creative prompting, users can often get these systems to ignore their instructions. That's what's called jailbreaking, basically. Right? If your entire safety and compliance architecture lives in a system prompt, it's vulnerable. Second, the LLM wrapper has no memory that it can be held accountable for. If your system prompt says never give an investment advice and the model gives an investment advice anyway, because the user was persistent, you have limited visibility into that failure unless you're logging everything, or most LLM wrapper implementations aren't. And third, the most critically from a legal standpoint, you have no explicit audit trail demonstrating that you took systematic steps to prevent specific categories of harm. And when you're in a courtroom defending your AI system and you say we had a very long system prompt, is not gonna be a compelling argument for due diligence, right? The solution that's emerging from the more sophisticated practitioners in this space is multi-agent systems, or MAS. Instead of one model trying to handle everything, you architect a system of specialized agents with distinct roles and separation of concerns. Let me break this down. Basically, at the top, you have a supervisor agent, and its job is orchestration, understanding basically what the user is trying to do, and ordering the request to appropriate specialized agent. The supervisor isn't doing the work itself, it's managing the workflow basically. Then you have a RAG agent, which is a retrieval augmented generation. And this agent's job is to ground every response in verified authoritative data instead of the language model relying on its training data, which obviously has a cutoff date, right? And can contain errors and is absolutely not specific to your business. The RAG agent retrieves relevant information, current, accurate information from your own knowledge bases before any response is generated. This is how you prevent the Air Canada problem, basically. Your chatbot cannot tell a customer about a policy that doesn't exist if it's forced to retrieve this information from your actual policy database. before responding. And then you have a compliance agent, sometimes called the guardrails layer. This agent sits between the rest of your system and the user output. Before anything reaches the user, it evaluates the proposed response against a defined set of rules. Is this response factually accurate based on what the RAG agent retrieved? Does it violate any regulatory constraint? Is it psychophantic? Meaning, is the AI just telling the user what they want to hear rather than what's true? Is there anything in this response that creates legal exposure? If the compliance agent flags an issue, the response does not go to the user. It basically goes back into the system for revision and escalation. This architecture isn't simple to build. It's defensible. You can show a court or a regulator exactly how your system works. You can demonstrate that you have explicit safeguards at multiple layers. You have audit logs at every stage. You have separation of concerns. The agent that retrieves information is not the same agent that decides what to say, which is not the same agent that validates whether the response is appropriate. And there's also a deeper principle here that I want to name explicitly. The move to multi-agent architecture is also a move towards legible AI. The systems whose behavior you can actually explain. The black box defense fails in court because it's not actually a defense. It's an admission that you don't know what your system is doing. Legible AI means you design the system so that you can always tell the story of how a particular output was produced. And that's not just good legal practice, it's good engineering. And with that, let me bring this home. Everything we've discussed today, the legal shift from speech to product, the Character.AI settlement, the Air Canada ruling, the agenting AI explosion, the governance architecture requires to manage it, all of it points to the same fundamental choice. You are either governance ready or you are liability exposed. There is no comfortable middle ground anymore. The companies that survive and thrive in the AI era will be the ones that took governance seriously before a crisis forced them to. The companies that treated governance as a compliance checkbox, something to bolt on after the product was built, will be the ones we read about in the future case studies as cautionary tales. And I want to close with something that I think at last in the legal and technical discussion. AI basically should be a tool for human flourishing. That's it. The reason we are talking about governance isn't because AI is inherently dangerous, it's because AI is powerful. And powerful tools demand serious responsibility. The same seriousness we bring to the pharmaceutical safety, the same seriousness we bring to aviation engineering, the same seriousness we bring to the financial fiduciary duties. AI can basically do extraordinary things. It can, democratize access to expertise. It can then compress years of research into months. It can help small teams compete with the much larger organization. But if none of those benefits are guaranteed, and all of them can be undermined by deploying AI responsibly. Deploying AI irresponsibly and having the backlash from the failure set the entire industry back. So let me give you the practical steps. These are the things you can probably take to your team. Probably, right? The action plan, what I say. Basically, the first step would be inventory your AI assets. You cannot govern what you don't know exists. This means going beyond your official AI deployments. Shadow AI. Employees using personal AI tools for work purposes is a real liability. You need a complete picture of every AI system that touches your business processes, your customer interaction, your data. Update your vendor contracts. Your existing SaaS agreement almost certainly do not have adequate indemnification clauses covering autonomous AIs and origination. So get your legal team to review every AI vendor contract. Ensure explicit language covering who bears liability when the AI does something wrong. This is not a nice to have. This is a must. Third, implement verification layers. In your agentic systems, implement mandatory human checkpoints for high-stakes action. Define explicitly what your AI agents are authorized to do autonomously versus what requires human approval. Create audit logs for everything. Audit logs. You must have them. Not just for compliance, for your own operational understanding of what your system is actually doing. Fourth, harden your identity management. As agentic system proliferate and your identity and access management infrastructure needs to basically have to evolve to handle these non-human identities. And AI agents should have the minimum necessary permissions. Those permissions should be reviewable, right? And the fifth, build for legibility from day one. If you're building a new AI system, architect them so that you can always explain how a particular output was produced. Use multi-agent architectures with separation of concerns. Implement the RAG and the compliance agent layers we discussed. And design for auditability as a first-class requirement, not an afterthought. And finally, and but not least, conduct a regulatory landscape review. Colorado, California, the EU AI Act. These are probably not the last laws you'll need to comply with. Assign ownership of AI regulatory compliance to someone in your organization, ideally with both legal and technical knowledge, and make sure you have the process for tracking this as the landscape continues to evolve. And that's the roadmap. It's not simple, but it's achievable. And the cost of getting it right now is fraction of the cost of getting it wrong later. The companies that are investing in governance infrastructure today are not doing it because they're required to. They're doing it because they understand that the trust is the ultimate competitive moat. When regulators tighten the screws, and they will, right, in future, the companies with robust governance system will adapt quickly, and the companies that have been winging it will not. And I just want to loop back to episode 8 one more time, because I think through line is important that in that episode we talked about dead internet theory, the creeping reality that much of what people consume is online is synthetic, bot generated, and algorithmically manipulated. The internet was supposed to be humanity's great connective tissue, right? Instead, a large portion of it have become an artificial ecosystem designed to simulate human presence and manufacturing engagement. That's what unregulated AI at scale looks like in the content layer. And what we are discussing today, lawsuits, liability frameworks, the governance architecture, is what it looks like when society starts, pushing back in the action layer. And so you want to be the company, the company that adapts, the company that your customer can trust, and be the company that when the next legal inflection point arrives, you already have the house in order. Okay, thanks for listening to episode 9 of Tanveer Talks. And if this episode actually gave you something to think about or something to bring to your team, or please share with someone who needs to hear it. Follow Tanveer Talks on Spotify so you never miss an episode. And follow me on YouTube channel, Tanveer Ramgarhia, handle is Tanveer Talks Official. And join conversation on X at Punjabi Gamer 786. I want to hear what you think. Right? I'll see you in episode 10 next week. Until then, stay ahead of the curve.